Okay, now somebody had emailed me and said that they had tried to look at one of the videos and that it was trouble with my microphone there. So I went back into YouTube and I reset the parameters so that everything would be public. I had tried to set it with private and then given you the specific sites to get there, but that evidently didn't work. So I changed everything from private to public. So those of you that are trying to look at the recordings, they should be accessible to you now. If they're not, please just let me know and I will see what I can do to change that. All right, so we're moving right along here. Let's take attendance to get that out of the way so that I can tell the school that I did what I was supposed to today. All right, so Nevaeh, you out there? Nevaeh Arnold?
Yeah.
Oh, there you are. Okay. Sydney Babel, I saw you out there. Jacob Blackburn? Jacob?
Here.
All right, thank you. Matt Castles?
Here.
Okay. Grace Sicky? Grace, I think I saw you out there. Madeline
I'm
DePalma.
here.
Okay. Madeline DePalma.
I'm here.
Great. Josh Grigoletti.
Here.
Thank you. Jeremy Groves.
Here.
Great. Travis Harvey.
Here.
Okay. Sydney Hips. I think I saw Sydney out there. Seyun Huang.
Here.
Okay. Kayla Jewell. Saw Kayla out there. Christian Kemp. I saw Christian out there. Yuta Koike.
Here.
Okay. Destiny Merriweather. Destiny? No? Okay. Jeremy Meyer. Jeremy's out there. Brock Newsom.
Here.
Okay. Anthony Phillips.
Here.
All right. Haley Phillips.
Here.
Jacob Smeltzer.
Here.
Great. Walter Tolliver. I saw Walter was out there. Hallie Vogt.
Here.
Okay. Autumn Wanchik.
Here.
May Williams.
Yeah.
And Ashley Wolford.
I'm here.
Okay, great. Welcome, everybody. Okay, so today we're going to continue talking about negotiable instruments. And we had started the chapter on, excuse me, got to be careful how you swallow that water. We had started the chapter on liability of the parties under a negotiable instrument. And let me go back to here. Let me just share the screen of the outline just so we can look at what we're going to be doing for the rest of today. So I know that we had started this chapter, which is chapter 29 in the book. We had started the chapter, talked about what a holder is and what a holder in due course is. And we talked about becoming a holder in due course through a holder in due course. So what we're going to have now is, I'll do a quick review of that, and then we're going to talk about the defenses against being a holder or a holder in due course. And then there's a special Federal Trade Commission rule out there, and then we'll talk about primary parties, secondary parties, and what happens in a situation of dishonor, where whoever the drawee is refuses to turn over the funds. So just a real quick review. A holder is somebody who receives a negotiable instrument, or an instrument, let's put it that way. And it is basically, it runs to them, meaning that it was properly endorsed to them, or it's a bearer instrument and they have possession. A holder in due course has to do more than just take possession of the document. A holder in due course has to actually give value. They have to take it in good faith. They have to take it without notice of dishonor or defense, and without knowledge that the instrument is overdue. So basically you have to, the good faith issue there is pretty big. The law only wants to protect the innocent people in here. So if you are somebody who is trying to game the system, either through theft or through, say, a forgery or changing a document, you're not going to end up being protected. So only the very innocent people, and we've talked about this in the past. All right, so let me go back to the outline so that I can actually, let me go to the book. Give me a second here. All right, so the next thing we really wanted to talk about is the defenses to a negotiable instrument. Basically, when we talk about defenses, let's start with talking about a contract. Okay, so last semester we talked about contracts quite extensively. So this, what we want to look at here is if you were a party to a contract and you did not want to follow through with that contract because you felt the other party was in breach. Say I pay somebody to paint my house. That was the big thing last semester. We had people painting my house constantly. But I get into a contract with somebody to paint my house. And the specifics were that a Sherwin-Williams paint, it had to be white, it had to be 30-year guarantee, exterior, it had to be done within a certain period of time. I come home the day that the painting was done on the house, and instead of it being painted white, it was painted gray. That's not what the contract called for. I wanted to have my house painted white, and I say, no, I'm not going to pay. Now, what will happen is the person who painted my house will more than likely want to sue me because they want to be paid for their work, whether they believe there was a misunderstanding or whatever their reason was for painting it the wrong color. We would end up in court. And they would make their case, hey, I painted the house, I deserve to be paid. We're gonna let some people in. Okay, and so then the judge would look at me and say, well, why aren't you painting him? Or why aren't you paying him? And I would say, well, Your Honor, the contract called for him to paint the house white. He painted the house gray. That's my defense. Okay, so that becomes the issue with me having a defense against the contract. I would probably not be required to make that payment. The judge would very likely say, all right, you're excused because they didn't do their part of the contract properly. Now, let's talk about a negotiable instrument. With a negotiable instrument, we have those types of defenses, okay? Somebody didn't do something properly, so we don't want to pay the instrument, okay? So if we get to the point where it's, the instrument was issued, it was given to the payee, and the payee negotiated it to somebody, if that person becomes a holder, then certain defenses are available against that holder. But if that next person in line becomes a holder in due course, the number of defenses available to avoid paying the holder in due course is a much smaller list. Okay, so if you look at the outline that I have out there, you'll see that I have as number 4 defenses against payment of a negotiable instrument, and then I have A, limited defenses, and then I have B, universal defenses. Okay, so limited defenses means that they are available against a holder, but not against a holder in due course. Universal defenses can be used against everybody. Okay, so if you are a holder in due course, then the limited defenses, ordinary contract defenses, incapacity of maker or drawer, fraud in the inducement, or I have other there, and we'll look in the book to see what that is. Those would not be available to the person who doesn't want to pay. Okay, as a holder in due course, those defenses do not affect you. Okay, so that being the case, let me go back to the book. All right, so let me just get to the right page here. All right, so classification of defenses. Defenses against an assignee or ordinary holder. All of them. Okay, limited defense is not available against a holder in due course. An ordinary contract defense. Okay, so I had explained that before just a few minutes ago. We got into a contract for you to paint my house, and ultimately there was something wrong with your performance, so I refused to pay on the contract. That's an ordinary contract defense. Now, one of the things that we didn't talk about is that we could do this as a contract, or we could do it as a negotiable instrument. The reality of it is that I could, if I was the person who was the painter in this situation, I would prefer that the contract between the person who owns the house and me as the painter of the house really be a negotiable instrument instead of an ordinary contract. Because if I did it as a negotiable instrument, then it's going to be able to be negotiated. I'll be able to sell that that contract as a negotiable instrument, and the people downstream from me have the possibility of being a holder in due course, so therefore they would end up being paid. Okay, so let's just assume that we did the contract as a promissory note as opposed to just a regular old contract for a service. Now, remember, we would have all of the appropriate elements in there to make it a negotiable instrument, which would mean that it would have no conditions on it, and it would be no, there would be payable in money and definite amounts and a definite time, so on and so forth. But let's assume that that's how we did it. We did it as basically a promissory note, that I had the homeowner sign basically a $5,000 promissory note to me, payable in 30 days or whatever the date that we felt that the painting contract was going to happen. Well, if I don't paint the house properly, I paint it gray as opposed to white, or I don't paint it at all, the homeowner would have an ordinary contract defense against me. Hey, he didn't do the contract. I'm not paying that $5,000. Now, if the promissory note is still in the hands of the painter, then we don't have this holder in due course stuff going on. This is just basically the two parties to the transaction, and my contract defense would be valid. Okay, I wouldn't have to pay the $5,000 because I would have a defense against that negotiable instrument. If let's say that the painter has negotiated that to somebody, but they didn't give proper value, or they didn't they took it knowing that there was a problem. You know, they took it in, they didn't take it in good faith. They knew that there was some sort of a default or problem with the note. Then they would not be a holder in due course. They would just be a holder. Now, as a holder, but not holder in due course, my ordinary contract defense would be valid against the whoever the holder is at that time. Okay, so I would still not have to pay. Let's take it to the next step. Okay, so the painter has the promissory note and negotiates it to somebody. It's $5,000 promissory note. There's no knowledge that it's not been let's say that the performance under the contract hasn't happened yet, but it's not due for 30 days, and performance is supposed to happen during that 30 days. At the end, and so during the 30-day period, the painter decides he wants to negotiate that, so he sells the note to somebody who qualifies as a holder in due course. So that means that they would have given value. They would have taken the note in good faith. They would take it without any notice of dishonor or well, notice of dishonor, and it's not past due because it's still within the 30-day period. They would be a holder in due course. So now the contract is not properly performed. I don't want to pay it, but now what I have is I have a holder in due course coming back at me demanding payment. If I go to court and refuse to pay, the judge would go to the plaintiff. Why do you want to be paid? Well, I have this note and I'm a holder in due course. And they would prove that they're a holder in due course. And the judge would say, why aren't you paying this? And I would say, I have an ordinary contract defense. The contract that this promissory note was based on was not performed properly. So I refuse to pay that promissory note. I would lose. Okay, this is a situation where the law would protect the system over me. I'm not a bad guy. I didn't do anything wrong, but the importance of protecting the payment system is more important than protecting my rights as somebody who I didn't get what I bargained for because they broached the contract with me. Doesn't mean I don't get any recourse. I would then be able to sue the painter, but I would still, because of the fact that the promissory note, a negotiable instrument, is in the hands of a holder in due course, I'm required to pay the holder in due course. Okay, I'm out $5,000. My house hasn't been painted properly. I'm going to sue the painter. Okay, what am I going to sue him for? Well, I'm going to sue him for the $5,000, and I'm going to sue him for whatever the costs are going to be to fix whatever the problem was, to change the color on my house, whatever it is. Okay, so an ordinary contract defense, not valid against a holder in due course. It would be valid against a regular holder, but not a holder in due course. Okay. What about incapacity of the maker or drawer? Now, drawer if it's a check or a draft, a maker if it's a promissory note. So ordinarily, the maker or drawer's lack of capacity, except for minority, may not be raised as a defense to payment to a holder in due course. Okay. Just another one of those defenses that's not available against a holder in due course. If, once again, if the negotiable instrument was transferred to somebody who qualifies as a holder in due course, then me saying, well, wait a minute, I didn't have capacity to enter into that deal, because remember, a negotiable instrument is a contract. I didn't have capacity to enter into that contract. Well, how would the holder in due course know that? Okay, once again, we want to protect the payment system, not the individual here. So there's a big advantage to becoming a holder in due course, because even if the maker or drawer is being abused in this instance, it's the payment system that the law wants to protect. Fraud in the inducement. Now we're going to find fraud on both lists. We're going to have fraud on the limited defenses, and we're also going to have fraud on the universal defenses. The difference is the type of fraud that's involved. This is fraud in the inducement. This is a limited defense, which is not available to be used against a holder in due course. Fraud in the inducement. Fraud that occurs when a person is persuaded or induced to execute an instrument because of fraudulent statements. This goes back to that you're trying to buy a car and you're test driving it, and you ask the salesman, hey, has this car ever been in an accident? And the salesman says, no, this car has never been in an accident. Well, when in reality, the car was in an accident and he's lying to you. We use that as fraud. Fraud is a misstatement of a material fact, which causes you to rely on that statement to your disadvantage. Okay, so this is fraud in the inducement. I'm going to induce you to enter into the contract by lying to you. Okay, so that's the fraud that you're used to seeing. So fraud in the inducement is a limited defense not available against a holder in due course. Yeah, so the example they give in the book is very similar to the one that I just gave. All right, miscellaneous defenses. Other limited defenses are listed in your book. Let's see, the first two, fraud and contract defenses, are the most common of the limited defenses, but other ones that are out there, let's see, number one, prior payment or cancellation of the instrument; 2, non-delivery; 3, conditional or special purpose delivery; 4, breach of warranty; 5, duress consisting of threats; 6, unauthorized completion; and 7, theft of a bearer instrument. These defenses have a very limited effect in terms of defending against a holder in due course's demand for payment. Okay, so that's another list, but the big two out there are fraud in the inducement and ordinary contract defenses. All right, that being said, let's talk about the universal defenses. The universal defenses are defenses that the person who's refusing to pay a negotiable instrument will be able to use against holders and holders in due course. So these universal defenses will defeat a holder in due course. That's the big thing. Definition: defenses that are regarded as so basic that the social interest in preserving them outweighs the social interest of giving negotiable instruments the free transferable qualities of money. Okay, so these are universal defenses, and let's see what they are. Fraud as to the nature or essential terms of the instrument. So here's the second time that we see fraud. Okay, the first one was fraud to the inducement. So I lied to you to get you to sign the contract or sign the negotiable instrument. Fraud as to the nature or essential terms of the instrument. This is where you are lying as to the fact that they're signing a legal document. Okay, this is where, hey, can I have your autograph? And you cover up the part of the page that has the writing on it, and you have them sign. They have no idea that they're even signing any kind of a contract, much less a negotiable instrument. Okay, so fraud as to what the whole nature of the document itself is fraud as to the nature or essential terms. Okay, so if you are that, you're lying to that extent, we will allow that as a universal defense. Okay, forgery or lack of authority. The defense to the signature was forged or signed without authority can be raised by a drawer or maker against any holder, unless the drawer or maker whose name was signed has ratified it or has stopped by conduct or negligence from denying it. Okay, so if it has been, if the document was forged, that is a universal defense that can be used even against a holder in due course. Duress depriving control. Duress. Remember duress when we were talking about capacity in contracts last semester? Duress was basically where somebody's will was overpowering yours. We had both physical duress and economic duress that we talked about last semester. Let's stick with physical duress. I'm going to have you sign this document. If you don't sign this document, I'm going to shoot you in the head. I've got a gun and I've got it pointed directly at your head. Sign the document or I will kill you. That's duress. Okay, was capacity involved? Was there any consent involved here? Absolutely not. It was not real consent. All right, incapacity. incapacity. The fact that the defendant is a minor who under general principles of contract law may avoid the obligation is a matter that may be raised against any kind of holder. Once again, you have to take, this may make sense to you, it may make zero sense to you, but the whole thing here is that in the law, we have to pick and choose who we want to protect. Okay, so we have a knowledge here, because we've got universal defenses and limited defenses, that we want to protect the holder in due course. And the only reason we're protecting the holder in due course is because we want to protect the payment system. All right. Now, prior to now, last semester, we talked about the law or the government's desire to protect minors. That's why there are so many rules out there about how a minor can void a contract, and minors, there's all kinds of things out there to protect minors. So now you have in the law, we want to protect the holder in due course, basically protect the payment system, and we want to protect minors. Which is more important, protecting minors or protecting the payment system? Well, as of right now, the policy of the government is we will protect the minor. Okay, so if the minor gets involved in a negotiable instrument and wants to avoid that obligation, then the minor can, and that's a defense against everybody, including a holder in due course. Why? Because that's the policy of the government. We're going to protect minors. They're very, very highly protected. Illegality. If an instrument is void by law when executed in connection with certain conduct, such as a note for gambling or one that involves usury, such defenses can be raised against any holder. I think the reality here is that you can't have a contract for something that's illegal. The contract was void right from the beginning. So I think that's really how this progresses through the law here, that it's not so much that, oh, we're trying to protect, there's a higher protection for something over the holder in due course or the payment system. I think this is just the law saying there's never been a contract. There's never been an agreement. There's never been a negotiable instrument. So therefore, it's a universal defense. Alteration. Definition of alteration is an unauthorized change or completion of a negotiable instrument designed to modify the obligation of a party to the instrument. So an alteration is where you take a negotiable instrument and you mark it up in such a way to change what the overall value or meaning of the document is. For example, if I were to, and this is what's in the book, if I were to write you a check for $150, you can see how a 1 could easily be turned into a 4. You find a pen that has the same color ink, you strike through the 1 with the extra little caret there and make it a 4. You'd also have to deal with the writing. So 1, could you make that into 4 in writing? I guess you could. It might be a little bit obvious, but that is an alteration. An alteration is a universal defense because we're not going to protect the bad guy here, right? The bad guy changed the document so that it changed the obligations. So that's not right. Okay, so person making alteration, by definition, an alteration is a change made by a party to the instrument. A change of the instrument made by a non-party has no effect. Recovery on the instrument is still possible under the terms of the instrument, as though the change had not been made, providing it can be proven how the document existed in its original form. So the document is not voided. It's not, it's not killed, so to speak. The alteration, if you can prove what the original document was about, what its value was, so to speak, the original document can be enforced, but the alteration cannot be enforced, and the alteration is a valid defense against everybody, including a holder in due course. Let's see, if the alteration was made fraudulently, the person whose obligation under the instrument are affected by that alteration is discharged from liability. The instrument, however, can be enforced according to its original terms. It has completed. This right of enforcement is given to holders in due course who had no notice of the alteration. While a holder in due course would come within the protected class of alteration, such status is not required for the recovery provision in the event of alteration. So even a holder could theoretically still collect under the original terms of the agreement of the instruments. Okay. All right. So let me see what our next thing. The next thing on the outline that I have is the Federal Trade Commission rule to deny holder in due course protection. This is an interesting issue here, and I'm going to move forward in the book to where that is. All right. This happened in 1976. Let me give you a fact situation, okay? And I'm much older than all of you, so I've seen a lot of weird things in my life. I actually, at one point, bought furniture at a traveling tool show. You know, this is back in around 1999, 2000. 1997, 98. I was setting up my law office and I needed a table. It was a little bit later, maybe 1998, 1999. I had bought an oak table it was a used oak table from a office supply company. And it was just, it was a beautiful table and everything, but it was just too big for my conference room. So I was looking to buy a smaller table. And I was reading in the newspaper. Yes, back then we had newspapers and we read them. I was reading in a newspaper, there was a flyer about a company that was coming to town. It was a traveling tool show where you could go and you could buy tools. And so once again, this is the very late 1990s. And I was interested in just going and seeing if they had anything that would be kind of cool to have, because I do have a collection of tools. I am a little bit of a handyman type thing. But so I decided to go to this tool show. And at the tool show, they had all kinds of tools, hand tools, power tools, compressors, pneumatic tools, big stuff, little stuff. And in addition to that, they sold some furniture. And strangely enough, at that tool show, I bought two pieces of furniture. I bought the table that is in my conference room at my law office. And the table has actually held up very, very well. So if I bought it in like 97, I've had it for well over 20 years at this point, I think. Do the math, but I've had that table for quite a long time and it's actually held up very well for me. So it was not a bad thing. And for any of you that have ever been in my office at Teal, I have a cheap grandfather clock over in the corner. I actually bought that grandfather clock at that tool show. But anyhow, although I did not have a bad experience with these things, let's just assume that this was a fly-by-night group that had come through town, and let's say that they convinced me that I should buy, a big, some big ticket items, and there was a lot of money involved. So I decided I'm going to buy a new, all new office suites. All of the furniture that I would need, client chairs, desks, tables, everything from this company, because, oh my God, I can't believe these prices. They are so good. Most places that sell you big ticket items are also capable of financing that for you so that you don't have to pay it all at once. So let's say that I was buying $6,000 worth of furniture to furnish my office. And they said, you don't have to pay us all right now if you don't want to. What we can do is we can set you up with a finance company and you can make payments. It's like, oh, maybe that's what I should do, is I should make payments so I don't have to pay all the money right now. So what they would do is they would then send me over to the financial people, because there's always somebody that is in charge of dealing with the money at and yeah, go to a car dealer, you talk to the finance people, right? So they would push you over to the finance people, and then they would set you up with a finance company. They may or may not be affiliated with them. Very likely they are affiliated with them. And so you take they take your application for the installment loan to buy the furniture from them. They approve you for the loan, and you get your furniture. So you get it, trucked over to your place, and you set it up in your home or your office or whatever. In the meantime, the way that the deal was structured is that you signed a promissory note to pay, let's say it was $6,000, and you agreed to make payments of X number of dollars per month for the next 5 years or whatever it is, at whatever the agreed upon interest rate was. A standard promissory note. The promissory note that you signed was with the traveling furniture company. Okay. Then what they do is they turn around and they sell it to somebody else that's going to hold the paper. Okay. So they may get $5,500 and then, whatever, but they're going to sell it to another person. And this is a very big, important key part of this. Okay. Because what happens is when you sign the promissory note with the traveling tool company or traveling furniture company, that is you're the maker of the instrument, and the payee is the company that you bought the furniture from. They're not a holder in due course. This is at this point purely a contractual relationship, and they don't want it to be a contractual relationship. They want this to end up being a promissory note that was negotiated to a holder in due course. Okay, so what would happen is these companies would go through and lend money to you so that you could buy the stuff from them, and then at the end of the day they would then turn around and sell all of that to some sort of a finance company that would give them the cash that they wanted from the sale, and then the finance company would end up collecting and servicing the loan. So they would get their money back in installments over the period of time, whatever I said 5 years before, and they would collect the interest rate. And it would be a little bit higher interest rate. It would not be a small interest rate, but it would be out there. The company that bought the note is a holder in due course. Right? What are the requirements? They have to give value. Yeah, they paid the furniture company for the note. They have to take it in good faith. Unless this is some sort of an inside job here, they are taking it in good faith. Are they taking it without notice that there's any kind of dishonor or defense against it? Absolutely. There's no defense or dishonor at this point. And it's not overdue, because at this point, not even the first payment has been made, and it's not due for 5 years. So the finance company becomes a holder in due course. Now, the reason that I made this a traveling furniture company is because they would set up a tent in a big parking lot usually from an abandoned store or closed store. So they have this massive tent and all these it's furniture that's on display, and all these trucks and semis that they haul their stuff around with them. At the end of a 4 or 5 day period, they load everything back up into trucks, and they take the tent down, and they're down the road to wherever they're going, the next city to 100 miles away. Well, the problem is that the furniture that you bought was crap. You use it, you just took out 5 years worth of financing on this furniture. And, they were in town for 4 or 5 days, they're gone. Say 6 months down the road, that company has probably gone to 5, 6, 10, 12, 20 different cities, and God knows how many thousands of miles away from you they are at this point. And your furniture just falls apart. It was crap when you bought it, and it's even worse now because after 6 months of use, there's just absolutely no quality to it, no value to it. It just falls apart. You're upset, and you still owe the better part of $6,000 on this furniture that is no good anymore. It's just garbage. Okay, you don't want to make those payments anymore. You are done. I am not going to make these payments. Thank goodness I took this out on credit, because at least I'm only out a few $100s for the payments that I made. I would be so upset if I would have paid the full $6,000 for this junk. I'm not making the payments. You tell the finance company, I'm not making any more payments because this furniture is garbage. And you know what the finance company is going to say? We don't care. We have a note here that says that you're going to pay us $6,000 over a 5-year period at this stated interest rate. You've made the first 6 payments. You still have 60 payments. You made 6. So you still have 54 more payments to go. And we want our payments. I'm not making any payments. They sue you. Now, the way the law is that I've described to you up to this point, what you have is a holder in due course, the finance company, and what you have is what? An ordinary contract defense. What you're saying is that the stuff that you were sold, either it was, it was given to you by fraud. They told you it was going to last for a very long time, but it didn't. Fraud by the inducement, right? Or possibly just a plain old contract defense that there should have been, this stuff should have lasted more than 6 months. So maybe you're going to sue under a warranty claim for fitness or excuse me, merchantability or something along those lines. But what you have is either a defense for fraud in the inducement or an ordinary contract defense. Is that going to be valid against a holder in due course? No. No. And so this became a problem. A lot of these traveling shows were going around the country just selling crap, and then selling it on credit, and then negotiating the promissory note almost immediately. So therefore, people were ending up with no ability to defend themselves against the finance company that was demanding payment. As its holder in due course, they were entitled to payment. Now, what's your recourse? Well, your recourse is against the original company, right? But very likely they're already out of existence, because these people were doing this kind of as a fraud anyhow. So they traveled, first off, if you can find where they are in the country, good luck to you. But secondly, they probably collapsed that company and opened up under a new name and a new corporation or whatever, sold all the assets from the old company to the new company and continued on. There's nobody for you to sue. You have no recourse anywhere. This was not a good result. People did not like this answer. Okay, so this is where the Federal Trade Commission steps in. So in 1976, the Federal Trade Commission adopts a rule limiting the rights of a holder in due course in a consumer credit transaction. Okay, so keep in mind, this has to be a consumer credit transaction. It's not anywhere else. This doesn't affect anybody else, any other holder in due course, other than somebody who is a holder in due course in a consumer credit transaction. The rule protects consumers who purchase goods or services for personal, family, or household use on credit. All right, reading from the book. When the note the buyer gave the seller as payment for the consumer goods is transferred, even to a holder in due course, the consumer buyer may raise any defense that could have been raised against the seller. Okay, so what the Federal Trade Commission rule does here is it makes all defenses available against even a holder in due course, against the promissory note, basically, if it's a consumer credit transaction. Okay, so now what we end up with is a lot of rules as to what has to be done in order for these things to occur. The FTC regulation requires the following notice be included in boldface, at least 10 points in size in consumer credit contracts covered under the rules. So if you are buying items for your home personal use in a credit transaction, the promissory note, because it's going to be a promissory note, requires this message in at least 10-point font. Notice, any holder of this consumer credit contract is subject to all claims and defenses which the debtor could assert against the seller of goods or services obtained with the proceeds hereof. Recovery by the debtor shall not exceed amounts paid by the debtor hereunder. All right, so that's the warning that has to be in there. When a notice preserving customer defenses is included in a negotiable instrument, no subsequent person can be a holder in due course of the instruments. Okay, now, if you don't put that on there, then you're violating the Federal Trade Commission law, and you're subject to punishment and enforcement by the Federal Trade Commission, by the United States government. If you do put it on there, thereby complying with the FTC rule, that means that anybody downstream cannot be a holder in due course. Well, I look at this as being, let's look at what is required to be a holder in due course. You have to give value. All right, well, they gave value. You have to take in good faith. Maybe. You have to take without notice of dishonor or defenses. You now know, according to the terms of the document itself, that you're going to be taking this subject to defenses. So realistically, I think you're probably spoiling the good faith requirement, and you're probably spoiling the third one, which is taking without notice of dishonor or defenses. So that makes it impossible for this particular promissory note to ever be a document that would allow you to be a holder in due course. Now, in the book, we have some other things, and I'm actually using a different version of the book right now because of the circumstances of where I am. But here's a little exercise in the book here, and let's do it as a class and try and figure out what the answer here is. Okay, analyzing this problem will help you integrate your knowledge about negotiable instruments. Sid's Salmon has purchased salmon from Fred's Fisheries. Okay, so Sid's buys salmon from Fred. Sid wrote a check for $22,000 to Fred. A thief broke into Fred's office and took the cash on hand as well as the unendorsed check from Sid. The thief took the check to Corner Cashing Company, CCC, and received $22,000 less the cashing fee of $2,000. Fred notified Sid, who then notified Commerce Bank, the drawee of the check that was stolen. CCC has presented the check for payment, and First Commerce refuses to pay. CCC says it is a holder in due course. Are you able to help First Consumer Bank or First Commerce Bank develop a response to CCC? Okay, so what we have is we have a check, which is a negotiable instrument that was stolen. Okay. First question, let me go back to my view here to see who's here. First question that we have is, how was the check written? It was written to Fred's Fishery. Okay. What kind of paper is this? Madeline, what kind of paper is that check that was written by Sid to Fred?
I mean, it's like a contract essentially saying that you're going to pay them.
Well, it's a negotiable instrument, which is a type of contract, but in the broader sense, is this bearer paper or is this order paper? Anybody remember? We talked about that last class. You know, the difference between order paper and bearer paper. And which is this? Jacob, order paper or bearer paper?
Bearer paper.
Nope. It's order paper. It's not very clear in the fact situation, but it does say that the check was written by Sid, payable to Fred. So payable, it's going to be, it should say on the check, pay to the order of Fred's Fisheries. So it's what we refer to as order paper. It's made payable to the order of a particular payee. What I talked about last class was that having it paid to somebody, having it stay in the form of order paper is one of those extra securities that you get when you go into the payment system. So this is indeed order paper because it's made payable to the order of Fred's Fisheries. Now the check is stolen by bad guys and then they take it and try to cash it. Actually do cash it at one of those check cashing places. What did they have to do to the check in order to cash it? Christian, what did they do to the check?
Have to endorse it.
That's right. They would have had to have endorsed it. Now they wouldn't have endorsed it bad guy thief. They would have endorsed it as Fred's Fisheries, right? So there's your problem. We now have what is in essence a forgery. Bad guys forged Fred's Fisheries signature or endorsement. Okay, so can Commerce Bank refuse to cash the check or honor the check when the check cashing company presents it for payment? In my mind, yes. I think that there's no problem with the bank saying, no, we have a stop payment order from our customer. And when we talk about the chapter on checks themselves, you'll see what a stop payment order is. Fred's had, well, actually Sid would have had to have done it. So I guess Sid would have, but the bank had been ordered to not cash the check. The bank did what they were supposed to by not cashing the check. And the other defense that's in there is that it was a forgery. And a forgery is a universal defense. So I think that the check cashing company is probably safe in not honoring the check. Suppose that Fred had already endorsed the check and then the thief stole it. Would CCC be a holder in due course? Well, I don't think CCC is a holder in due course because they didn't offer up any value, so they never turn into a holder in due course. But that would have been a big mistake on Fred's side because Fred, having endorsed it, turned order paper into bearer paper. So then CCC has a better chance of being able to cash the check because of the fact that it was bearer paper that they had. This comes down to that situation where if you lose bearer paper, it's like throwing $100 bill on the floor. So Fred should not have endorsed it until he was ready to cash the check. All right, let me see what's next on our hit parade here. Primary party, secondary party. Okay, so let's look at the liabilities of the primary party and everybody else in line. So we have negotiable instruments. Primary party, definition of a primary party is a party to whom the holder or holder in due course must turn first to obtain payment. That's a primary party. That's the person who is basically the drawee of a check. The person who is going to have the draft or the check or the promissory note presented to in order to have payment, final payment made. So if I have a $5,000 check, I would take it to the drawee bank. Okay, so the drawee bank is the primary party on a check. Okay. What about a a promissory note. So let's stay with a promissory note first, because that is what a promise to pay as opposed to an order to pay. So a promise to pay, a promissory note, the primary party is going to be the maker. So if I borrow money from the bank and I sign a promissory note, I, John Gamalchak, hereby promise to repay to First National Bank the amount of $5,000 with accrued interest at 10%, 90 days after the date of this promissory note. As the maker, I'm the maker because I made the promissory note. The payee is the bank. At the end of 90 days, the bank is going to come to me with that piece of paper and they're going to say, pay up. I am the the primary party because I'm the maker of that note. I'm where the money has to come from to satisfy that document. Okay. Now, if we talk about a check or a draft, then it's not the maker who is the primary party, but it's the drawee. Now, if it's a draft, that means we don't have a bank involved. That means we have somebody else that's holding the money. A weird situation. It exists in the world, but that's not the common way of doing things. Let's talk about a check. So if I write a check, then the drawee bank, the place that is holding the money, becomes the primary party. So if I give you a check and you decide even if you negotiated, whoever is the holder of the check, whether they be a holder in due course or just a holder, is going to eventually go to First National Bank and say, hey, Gamalchak said this check's worth $100. I'd like that money. The drawee bank is the primary party. They're the party who is supposed to dish out the cash to make the document good, to honor the negotiable instrument. All right, so does that make, if I'm the maker of a promissory note, does that make me ultimately responsible to pay for the amount of the negotiable instrument? Yes, it does on a promise to pay, because I would be the primary party. I would be the maker. I would be the person who has to cough up the money. What about a bank? The bank is the drawee bank. They are the primary party who is supposed to make the money available, but the bank is not primarily responsible. See, the bank is only going to turn over the money if there's money in my account to honor the check, okay? The bank always has the opportunity to say, no, we're not going to honor this check because it's based on a contract with our customer that we're only required to honor that check if there are funds to cover it. All right, so the bank does not necessarily become the responsible party. They're the primary party. That's who you're turning to for payment, but they are not the responsible party. All right. Secondary parties. There's secondary obligors under Article 3 of the UCC. These are parties to an instrument to whom holders turn when the primary party, for whatever reason, fails to pay the instrument. Okay, so on a check, the primary party would be the bank. It's a drawee bank. But if the bank dishonors the check, refuses to honor it, does not pay it, then I'm still ultimately responsible because I am the drawer, okay? Secondary parties. Who are the secondary parties in a transaction where we've had a negotiable instrument go through the payment system? Well, the secondary parties are going to be the people who have endorsed the check. Okay, endorsed the check. Secondary parties on notes are endorsers, and secondary parties on checks and drafts are drawers and endorsers. Okay, so if the promissory note is not honored and it has gone through as a negotiable instrument, it's been negotiated to a few different parties, Okay, we'll start with the promissory note. I make out a promissory note for $5,000 and I give it to Bank A. Bank A is not the type of bank that holds on to onto loans. They then sell it to another bank, and they do it appropriately. They get value, good faith, no notice of dishonor, not past due. So the next bank would be a holder in due course, and then everybody behind that holder in due course is going to be a holder in due course, either because they qualify as a holder in due course themselves or because they took from a holder in due course. So they have, they have the ability. They're just, the limited defenses are not available against those banks downstream. Eventually somebody presents me, say the first bank that gets it after the bank that I get into the contract with. So the first holder in due course now approaches me and says, hey, Gamalchak, you got to pay this $5,000. And I go, boy, I really wish I could. I wish I had the money, but I don't. Sorry. Well, I'm primarily responsible, but I'm not going to pay it. The second bank, Second National Bank, so to speak, is now holding a piece of paper which doesn't have any value, and they paid, say, $5,000 for it. They have the legal right to go after anybody that was prior to them in the stream here and who endorsed it. So as long as it wasn't an endorsement that said we don't take any responsibility for this, as long as it's a normal endorsement, then those endorsers, by doing the endorsement, have guaranteed that the document will be cashed. So Second National Bank, since they can't get the money from me, they're going to go back to First National Bank and say, hey, you guys endorsed this, you now have to make it right. So they're a secondary party. Okay, let's go back to a check. I write a check and I give it to Albert, who gives it to Bob. Bob presents it to my bank, First National Bank, and they say, yeah, we'd love to give you the money, but Gamalchak, he's a terrible person, writes bad checks all the time. There's no money in his account. We won't cash it. It's being dishonored. So Bob went to the Draw E-Bank, which was the primary party. They didn't pay, but they don't have to pay. Then they're going to go for the secondary parties. Well, the secondary party is going to be me as the drawer. And if you can't get the money out of me because I don't have the money anymore, then you would go to people who have endorsed it. So whoever A was in my stream here of who got this check from me, Albert, I think, Bob would go to Albert and say, hey, you got to make Gamalchak's check right. You made the guarantee on this that the check was good. So then, that's what's the important thing about all these endorsements. And that's why when you go to a bank and you have a bearer instrument and whatnot, they want you to endorse the check. They want you to endorse the negotiable instrument. Why? Because by endorsing it, you are making the warranties and become a secondary party, become a secondary payee or obligor under the terms of the negotiable instrument. Okay. All right, just one thing that's not on the outline, but just another vocabulary term in here, presentment. Presentment occurs when the holder or holder in due course of an instrument, orally or in writing or by electronic communication, to the primary party requests that the instrument be paid according to its term. Okay, so that's presentment. You have to have presentment before any of these legal rights are triggered. The primary party is not required to make payment on the negotiable instrument until it has been presented for payment by anybody, whoever has a legal right to the document at that time. Okay, now one of the interesting things, looking at what the book says here about presentment, First off, the presentment has to be done in a commercially reasonable manner. So I can't require you to meet me at the North Pole on midnight of January 1st in order to do a presentment. You know, I could require it to be at a reasonable place during business hours, that type of thing. But beyond that, the primary party can also require identification, authorization, and even a signature of receipt of the funds due under the instrument. In addition, the primary party can demand a valid endorsement on the instrument prior to making payment. So as I said, you have all of these rules that make it appear that your bank is doing things wrong. They're allowed. Okay, and the whole point of this is, and I always wondered this. I always, you know, before I understood the whole process here, I thought, you know, this is bearer paper. If I took in a check to cash, they shouldn't require me to sign it because it's bearer paper. All that's required is that I have physical possession of it and I present it for payment. Well, the bank's going to require me to sign it. They're going to require me to have an account with them. Why? Because they don't want to be the ones who end up not having recourse against anybody. Okay, so, all right, well, you have to have an account here because if this is a bad check, we're just going to take the money out of your account. Or at least, well, we're going to require you to sign it and show some form of identification because we want to be able to know who you are in case at some point this is dishonored. We have the ability to make you secondarily liable on this particular instrument. Okay, so the fact that your bank is requiring more than it looks like the UCC requires, well, they are, but they're allowed to do that. It's just one of those things where the bank is trying its darndest to not be the one who's going to end up being harmed if the document's not honored. All right, dishonor and notice of dishonor. I think this is the last thing in this chapter here. Dishonor, definition, status when the primary party refuses to pay the instrument according to its terms. Okay, so promissory note, I promised to pay. You've now come and asked for payment on the note, and I go, nope, not going to make the payment. I wish I could, don't have the money. Guess you'll have to sue me, but not going to get anything because I got nothing. That's dishonor. Okay, I've refused to pay according to the terms of the instrument. Let's talk about a check now, because a check is the more common version of this. I write a check, I give it to A, who gives it to B. B presents it to my bank. B is told, no, this is dishonored. We refuse to pay the. We refuse to pay it. That's been dishonored. Okay, so you know, in the real world, the bank in the physical world, the bank would give you the check back, would have a big stamp on it that would say NSF and non-sufficient funds, or refused, or void, or some sort of notation on it showing that the bank had denied the payment on the instrument. The bank in the banking world has a limited amount of time in which to notify the parties as to the dishonor. Okay, so what do we have here? Okay, a bank must give notice of dishonor by midnight of the next banking day. So if B presents the check to my bank on, say, Tuesday, and the bank takes a look at the check and says, oh, no, this is not going to be honored, you know, there's no money in this account, they have until midnight Wednesday to notify B that they've dishonored the check. So, you know, it could be close to a day and a half, so to speak, for the notice of dishonor from the bank. So midnight of the banking day, of the following banking day. Then, of course, what would happen is B would then have to tell A that it's been dishonored. He'd have to give notice of dishonor to A. But a non-bank party must give notice of dishonor within 30 days following the receipt of notice of dishonor. So B would have 30 days to notify A that, hey, that check was not honored and I'm going to need you to make that right for me. Okay. So a bank by midnight of the following business day. Okay. So that's when it has to be done. We'll go back a page here. And I want to talk about how things have changed over the years. And at this point, this isn't new technology anymore. This is stuff that is probably second nature to you. Realistically, very few of you, I'm sure, are even using checks out in the real world. When I was a younger person, if I wanted to go shopping, credit cards existed, debit cards were coming into existence when I was a younger adult. And most of us still just, when we went to the store, we took our checkbook with us and we wrote a check. So if I was going to the grocery store, they would ring up my groceries and then I would write a check to Giant Eagle for the purchase of my groceries. Each vendor, every store had its own rules as to who they would take checks from. A lot of stores, you had to sign up and be on their approved list of people that they would take checks from. And they would keep track. If you bounced a check on them, then you would lose your check cashing or check using privileges and things like that. But we have now the advent of the digital world. And of course, most of us are using, I don't know the last time I was actually in a store and wrote a check. I just use my debit card or my credit card. I try not to run my credit card for things that are, day-to-day purchase. But, excuse me. Oh. But I use my debit card, that's connected right to my checking account. So if I go to the grocery store and I want to buy groceries, I'll use my debit card. I don't use my checkbook anymore. But if you were to go to your grocery store, or you were to go to Walmart and you wanted to write a check, let's say you're somebody that does not have a debit card or a credit card. There are people in the world that fall into that category, and they would have to either carry cash or carry their checkbook with them. But if I were to go into let's say Walmart, because I've actually seen this happen at Walmart. There was a time that I had lost my my debit card and I went into Walmart and wrote a check at Walmart. What they did kind of astounded me. I didn't realize this technology existed. So once again, this is a few years ago. So I wrote a check to Walmart, and Walmart, the cashier, took the check and said, okay. They made sure that it was made out properly and everything. And they took the check and they inserted it into the electronic cash register that they were working at. And basically what you'll find when we do the chapter on checks is that the writing on the bottom of your check is very special. It's called MICR encoding, magnetic ink character recognition. And what happens is when it goes through, when it was inserted into the cash register read the check. It read the routing number, knew which bank my check was written, my checkbook, my checking account was in, and it read the checking account number. The cashier then typed in the amount of the check, which then the computer went out onto the financial networks computer system out there, accessed my checking account, did an inquiry to make sure there was enough money in my account to cover that check, and then treated the check as if it was an electronic request for payment. And the payment was made immediately because of the request that was made by that cash register at Walmart. After that transaction all occurred, which took a matter of seconds, the cash register spit the check back out, and it was returned to me by the cashier saying, well, we don't need this anymore. This has been processed electronically. So they didn't need the physical check to get paid. In the old days, we would take the checks, bundle them up, take them to the bank, and the bank would process them through, and we would get paid the next day. Nowadays, it's all done electronically, where the cash register has the ability to turn that into a point of sale payment directly electronically from your account. Same thing happens if you use your debit card. You put your card in the machine, it asks for your PIN number, the computer goes out, accesses your bank account, makes sure that you have the money to cover the transaction, and then it removes the money and gives it to the store right then. One of the things that is different in the world from when I was a younger person is the concept of float has disappeared from the world. Float is a part of the money supply. So if you're in your economics class, you could talk to Gene Ninian about this and talk to him about what float is. But it's money in the money supply that gets created because the money is in two places at once. So in the old days, I would write that check to Walmart. They would take it and give me credit for the $100. So Walmart would then deposit that check, and it would take 3 days, let's say, for Walmart's bank to ask my bank for that $100 that the check was written for. In the meantime, Walmart has a deposit. Their checking account has their account has gone up by $100 because they have the check, and my account has not yet been reduced by the $100. It hasn't been hit by the check yet because it's still in process. So there's a big chunk of the money supply that is now sort of gone because we now deal with instant transactions. I give my check to Walmart, it immediately accesses my checking account electronically and removes the money immediately. There's no time delay for the check to go through the payment system. We will talk about that in a chapter or two, but it's just one of those things that when I was young, float was something that you could count on in the business world. You could spend the money before you had it because you knew float was going to protect you for a certain number of days. Economically, realistically, the money supply increased by the amount of money that was in float. Different things have happened. It's different now. Electronically, things have sped up. I don't know if that's a good thing or a bad thing, but it is. Just a quick review. Taking a look at the outline for chapter 29. We know that somebody who has a possession of a negotiable instrument is a holder. A holder in due course is somebody who has gone through the proper process to obtain special protection. You can get a holder in due course status through a holder in due course. There are limited defenses that are only available against holders. They are not available against holders in due course. There are universal defenses, which are available against both holders and holders in due course. We have the Federal Trade Commission rule, which denies holder in due course standing to lenders in consumer credit transactions because of the abuses that were noted. We know who a primary party is. That's the person that you expect to make good the transaction and actually turn over the cash for the amount of the negotiable instrument. Secondary parties are parties that you look to for payment if the primary party refused to make payment. We have notice of dishonor. We have dishonor was when the primary party refuses to pay. A notice of dishonor has to be issued. If you're a bank, you have till midnight of the following banking day. If you're not a bank, you have 30 days in which to do your notification of dishonor. Any questions? That's that chapter. We finished it in good time. If there are no other questions, as of right now, we're still planning on meeting remotely on Thursday. Things are looking up for me in my personal life and my son's health, but he is still in the hospital. So let's stay with a remote class on Thursday, and then I'll give you updates as I am aware of what's going on in my life. If there's no other questions, then that's the end. We'll see you guys on Thursday.
Have a good day.
Thank you.
Bye, thank you.
Thank you, Grace.
See you next class.
Okay, thank you, Jimmy.